quorum? Oh, there we go. Okay. So let's start with a roll call, please.
Trustee Clayton,
Here.
trustee Dickon,
Here.
trustee Eastman, trustee Haber,
Here.
trustee Hollander,
Here.
trustee Jamerson,
Here.
President Ford.
Present.
And we should just note for the record that we're conducting this meeting remotely because of the ongoing disaster proclamation that the governor of Illinois has issued, which allows us to suspend the requirement for in-person meetings.
Okay. First order of business, approval of the minutes. May I have a motion, please?
So moved. Second.
Are there any questions, comments, additions, corrections? Trustee Hollander,
Oh, no comment.
there's a little hand up by you.
If there is, I don't see it.
Yeah. Oh, I'm sorry. That was my screen.
Maybe it's a
Glad
fly.
these are going to be over pretty soon.
Right.
Oh, look, I can put it over your face.
Yeah.
All right. All right. Hearing none, roll call, please. All in
Trustee-
favor, roll call, please.
Trustee Clayton,
Aye.
trustee Dickon,
Aye.
trustee Eastman, trustee Haber,
Aye.
trustee Hollander,
Aye.
trustee Jamerson.
Aye.
Thank you.
Next item is a report by the village ecologist. No report this time. Treasurer's report. Our treasurer is with us.
Yes, he's done with his season and hopefully with you very often. Okay, the interest rate environment would be a nothing factor. It is very, very bad out there in terms of current interest rates. The actual status of our investments is still good. We've got about a market value of 8,143,000 in investable amounts right now. It is broken up as 45% in CDs, 31% corporate paper, and 24% municipals. Our current blended rate is about 1.33. And when I tell you what the new rates are, you'll see that our yield is going to slip. We're talking about right now about $125,000 annually cash flow on the assets under the current investment scenario. I asked Danielle for an update today because there was supposed to be some news coming from Goldman Sachs regarding rates, and I don't know that it ever came out because she didn't get back to me by the end of the day. But we're talking about right now, Treasury's 1 year is 0.04. So it's not even 1%, 0.04. 2 years, 0.16, 3 years, 0.33. You've got to go out 5 years to get close to 1%. And that's beyond our statute. So it's not even considerable at that rate. We have coming due, there's going to be various different issuances that we have, and I stopped at about the end of September. So through September, we'll have 1.5 million available for reinvestment, and we're going to stay very short term with those. She hopes. What was there was a new issuance today, something around 0.25 that she was hoping to get. So we're talking 0.25%. That's where things are at on this schedule in the short term market. So even though there were inflation worries a little bit that sent the market down, the stock market in general, they have not reflected into the fixed rate investment world of bonds and treasuries or even CDs. There's a lot of issuances coming out, new issues, but the rates are terrible. So I still don't think we want to be out of it, but we're not going to go very long with this, hoping that these bottom out rates will be here for less than a year. But that's an update of where we're at. And no defaults, nothing negative on anything that we have. Just unfortunately, some of the ladders are starting to come due.
Are there any questions for the treasurer? Well, I congratulate you and Danielle. I think they're doing a great job for us. I think they're doing a great job for us, and I thank you for watching over that.
Absolutely, my pleasure.
Thank you so much. So good to see you, kind of.
It's nice to be back. It'll be nicer when we're all together, which will be soon. Hey, we can go to a Cubs game. We can certainly go to a village meeting.
I don't know. They're a little different. Thank you, Hal. Thank you.
You're welcome.
Engineers report, please.
Just a brief update on our water meter AMR upgrade. The best I could do when I talked to Tim O'Connor with Midwest Meter yesterday to try and nail him down on when we might expect delivery. After much wheedling, I got him to say maybe August. As we know, there are all sorts of supply chain issues everywhere, and so everything is just ready to go. We're just waiting on the delivery of the equipment. So probably not a lot more on that front until at least August, but that's all I have.
Does anybody have any questions for the village engineer at this point? Thank you, Pat. Russ,
Chris,
Director of.
Chris, I
sorry.
just received an email from trustee Eastman that he's trying to get in and he's having a difficult time.
Oh,
Daphne, you might let him know that the Zoom link in the second final packet email is not the same as the Zoom link in the first one. If he uses that one, he should be able to get in.
Okay, I'm just gonna see if I can invite him. Copy invite link. Okay, I'm just gonna see if I can send him an email. Okay, thank you.
okay. Russ, do you want a Director of Community Services, please?
Sure. We had some problems with red tag Mr. Scora for his vinyl fence about 3 months ago. Well, I like to report that Mr. Scora has rebuilt his fence and it's the code as of this time. So finally got him to do what he's supposed to do. And got a lot of permits coming in. We're busy. Spent a lot of hours, a lot of time. And I gave out 2 red tags today, found 2 people doing stuff without permits. So it's unfortunately I can't get out as much as I'd like to do some code enforcement, but when I do, I'm finding some stuff. So if anybody sees anything or notices anything, please don't hesitate to call. Let me know about it. Bunch of eyes are better than just my 2. So that's about it.
Are there any questions for Director of Community Services? Okay, thank you. Zoning Board of Appeals did not meet. Plan Commission report, please.
The Plan Commission held a public hearing on June the 3rd to consider a request by the owners of the house at 2240 Riverwoods Road to reduce their side yard from 30 feet to 22 feet to allow the construction of an elevator to the existing building. The residents made the request because they are suffering disabilities and might not be able to stay in their home if they cannot put the elevator on their house. The Plan Commission discussed whether a waiver from the zoning ordinance should be granted as a reasonable and necessary accommodation under controlling laws. And we decided to vote in favor of recommending the waiver to the board. The description of our discussion is in your packet.
Yeah, I think our discussion will occur then under new business. Okay, thank you. Police report, please. Bruce, you're muted.
Wouldn't let me unmute. You can hear me now, right?
Yes, absolutely. Thank you.
Yeah, but I was hitting the button and nothing was happening. The police activity since the last meeting is in your board packets. We recently auctioned off a retired police car, a 2017 Chevrolet Tahoe, for $19,901.01. After the 3% commission to Obernoff auction, which totaled $597.03, we received a check today for $19,303.98. And everything else I have is on the agenda.
Okay, any questions for the chief? Okay, moving on, village attorney, please.
I just would quickly say that I haven't received any recent inquiries from potential developers of either the Federal Life parcel or the 37-acre parcel. I assume everybody is working away on some due diligence questions, but nobody has contacted us to set up anything since our last set of discussions, whenever that was. But I assume that something is still ongoing. I haven't heard anything to the contrary. With respect to GMX and the Thornton's development, they've had some discussions with Lake County Department of Transportation. Their architect has contacted us about necessary submissions to get before the Plan Commission. They were hoping to be before the Plan Commission in July. Don't think they'll make that, but they appear to be trying to put together necessary documents to make a full submission for the station at the corner. On the subject of resuming our in-person meetings, the Open Meetings Act has as a requirement for suspending the in-person meeting requirement that the governor has issued this disaster proclamation, or an emergency of this sort exists. And the governor has been renewing his emergency proclamation every 30 days. The last time he renewed it, it was May 26th or something like that, and it goes to June 27th, as I have read about it. If the governor doesn't extend it again, then the statutory basis for us suspending in-person meetings would go away. There is a supplementary finding that the village president makes that a disaster is occurring, but that's on top of the fact that the governor has made the proclamation. So it doesn't require a vote of the board. And if the governor does renew the emergency proclamation, then it's still up to the village president to make a determination as to whether or not an emergency exists. Just anecdotally, it appears there's somewhat of a consensus that we ought to try and resume in-person meetings if we can. So we have scheduled a zoning board of appeals meeting, first one we've had with our new chair, Sherry Graditor, for July 7th. And I didn't provide that there would be any kind of remote meeting or Zoom details. We just provided for it to be an in-person meeting at the Village Hall on July 7th. So I'm assuming, and this is, it is a matter for discussion, of course, but I'm assuming that unless there's some reason that the mayor wants to, keep having remote meetings, if the governor's order is not renewed, or even if it is, but it's still allowed, there's no capacity limits of the nature that there used to be. I'm assuming that the village would then resume in-person meetings in July, but I'm sure that everyone's views on this want to be heard.
Bruce, let me ask you a question. Remote participation. Should we go back to in-person meetings? Remote participation, how would that work for us?
Under the current rules that the Board of Trustees has adopted, we basically mimicked what the Open Meetings Act allowed, which was that trustees could meet remotely as long as we still had a quorum at the Village Hall, and as long as the reason the trustee was not present but meeting remotely was due to illness, unavoidable travel, disability, something like that. Now, I have spoken with some attorneys in other villages. They've been more liberally expanding those rules a little bit to make it easier and more convenient for any trustee who wanted to continue to meet remotely without having to go through any kind of, trial by fire, to just simply say, I prefer to continue to meet remotely. So I don't think this board would object to anyone who wanted to continue to meet remotely on that basis. But that's what the current rules of the board provide.
Would it be, as opposed to discussing that right now, would it be useful for a poll of the board to see if they wanted to make our rules for, there's a great feedback here. I'm not, is everybody else hearing that?
It's only when you talk, Chris. Sorry.
I was unmuted, that might have fixed it.
Okay, is it fine now?
Yes.
Okay. No, that's okay. That's okay. Could I poll the board to get their feeling on the liberal application of our current participation standards? Or do we have to have that discussion at open meeting?
No, we can ask now, what's the sense of everyone? I think it's fair to ask, and if you think the board rules ought to be somewhat more relaxed, we can address that at the very next meeting. What is it you all are thinking?
Trustee Jamerson.
Well, I don't have a problem with relaxing the rules. If a trustee is on vacation, I would just say that personally, when I'm on vacation, I want to be on vacation. So I probably would not attend the meeting, but I would also want to make sure that it doesn't get abused and that trustees just don't show up because it's easier to sit at home than to come to the meeting. Because I think my personal feeling is that there's better collaboration and input when people are meeting in person. So I don't have a problem relaxing the rules, but I would like to see maybe some kind of limit on the number of times a year or something like that.
Yeah, I'd like to just clarify. I said relax the rules because I'm speaking extemporaneously. It wasn't that we were changing the rules, but basically it's the idea that if someone says that because of various health reasons or concerns, they can't attend the meeting, it basically says we take the trustees' claim for that reason. We don't really try and delve into it. So, there is supposed to be some reason for it. It's not supposed to simply be for vacation. No one has said, we're allowing people who are on vacation to do that just because they're on vacation.
Trustee Hollander.
Yeah, let's assume that there is a valid reason. How do we do that structurally? I mean, do we have the ability to put someone's video on the screen behind us who's calling in, or is it just voice?
The requirement is that they can be heard and that they can hear. So an audio call-in is perfectly acceptable for remote attendance.
I understand, but are we set up for that?
In the past, we've brought a phone into the boardroom. So I think that's basically.
We are set up. The AV equipment in the boardroom is supposed to be able to handle that. We've never had to test it. And we did go, I didn't. Some of the staff went through training just prior to COVID. Whether anybody remembers the training or not is another story. Supposedly we have the ability to have two-way communication in the boardroom.
And it is true that if you're not present, you cannot vote. Is that correct?
I think that's right. They count as a quorum, but they don't vote.
I thought you said you had to have a quorum. You said that we had to have a quorum present.
But right, that's true too. But in other words, they can participate in the meeting.
Okay.
Under those rules, but you need a quorum at the village hall.
Yeah, but still cannot vote. But we don't have, do we have any provision right now for a remote attendance by the public then?
We've thought about, talked with Trustee Dickon about it also, about, trying to figure out how we could have hybrid meetings in the future that used some of the Zoom platform or one of those platforms, whether it would be, one computer camera screen looking at the whole village hall, whether each trustee would have us, their laptop in front of them, but I don't know, Lilia, maybe you can speak to it. It's more than I am competent to speak to.
Yeah, you know what, I've looked into it. There's a couple options, a couple different ways we could do this. I'd like to test it next time I'm going to be at the Village Hall. And I think that's probably going to happen next week. So I'll get back to everyone with a couple solutions, but I think it's very doable, and I'm sure I'll be able to figure out the existing equipment in the conference room.
Okay, all right, so we can get back to, we can report back on that kind of, okay. But right now, I'm going to suggest to you that meetings, board meetings, not committee meetings, so forth, ZBA, the Plan Commission will be in-person meetings
In July.
in July, beginning July 1st. Okay, moving on from that to information items and comment. Were there any questions for the village attorney? Any comments? Okay. My comments, I wanted to just simply draw to the trustees' attention the IML annual conference. And if you're interested in attending, let me know, and we can maybe suggest different sessions that, so we're not all attending the same session, so we can get a little bit more coverage. That is if you are interested in attending that. I want to talk a little bit about at the end of the meeting, when we set our next meeting date, whether or not we will be having a meeting on July 6th, which would be the first meeting in July. We talked about in-person meetings. The campus review, we're going to walk the campus on the 22nd, and we'll make a final determination on when we're going to open that, and then hopefully get something together for mid-July for a grand opening. So that's the intent, and I'm hoping that our walkthrough on the 22nd will support that kind of view. So after having said that, our next item is visitors wishing to address the board.
We don't have any emails, Mayor.
Okay. Okay, I see a hand here. Ms. Mayer?
Yes, I would like to address the board about a violation, and I have my neighbor who has a violation as well. So we.
And your name, please, sir?
Gregory Blazer.
So.
Okay, and you are both on Shawnee Trail, correct?
Yeah,
I'm sorry, can he spell his name?
Gleyzer.
Thank you.
You're welcome.
So currently I'm at 1477 Shawnee Trail. I mean, I do have pictures or things to share. I don't know if I'm allowed to share my screen about the violation. It's about the culvert and rocks in my culvert. And I think it was because it said I didn't get a permit. I didn't know I had to have a permit for that because I've had rocks in my culvert, so they were just put back. So I guess I want to see what can be done. I mean, can I share my screen, or is that?
I'm not entirely sure if we can do that.
I mean, I know
technically even.
Well, I think Daphne can probably let her share her screen.
Hopefully you can see my screen now.
Yeah.
Okay.
All right, I'm just gonna. So I just have a picture of my home. This is from Google Maps, just so that people are clear what it looked like before there was anything done. A couple of things to note: in 2018, I contacted the village 3 times in regards to my pipes here that were completely closed down. And I was told when there was enough people to change the pipes out that they would do it. I contacted the village again in 2019. Nothing had happened. If this was pictures, again, I took this right off of Google Maps. This is not my picture because I wanted to show it's October 2018. You'll see I have a ton of water in the culvert here. It's rather dry everywhere else. And then you can see my neighbor, Greg, who's sitting next to me. He has rocks in his drainage that he's had since 2016, since he closed on his home and he had this before he received his occupancy permit, which he can go through and tell you about that. This is my home now. I replaced a couple of things. One is when we received the violation, one of the reasons for adding rock here was to make mine level with Greg's, because the water flow through the village is going that way towards my neighbor's house and south. The house down here, I don't know if you can see my pointer, but the house down here, that culvert was completely closed. When we received the violation, we did contact Patrick Glenn and let him know the culvert was completely closed, just like mine was in 2018 and 19, with 4 calls to the village and yet nothing done. I did replace mine last year in 2020, did pay for it out of pocket, got a permit, followed the guidelines, replaced my own culvert. When the violation came that when I put the rocks down, which I did not know that I needed to get a permit so that this water would continue, this would be even with Greg's because the water flow is that way. And we pointed out that this culvert was completely jammed down here. All of a sudden, within 2 weeks, that culvert was replaced. I had 4 calls to the village and no culvert replaced. And I ended up, you can see here, it's brand new one. Driveway, I did that in 2020 because I couldn't wait for the village anymore because water was backing up into, it was not draining down that way. So because the culvert was completely smashed and closed down. This is what it is currently. This is the violation received. It is 2 things here. This is looking from my house to Greg's house, and then you can see one thing, it's completely even. In the previous picture, there was quite a big gap, and then the water would sit. So this actually closes that gap and helps with the water flow in the direction that it's supposed to go. I received that violation. The violation says all the rocks have to be removed. I also sent a letter to all of you guys as trustees. I have, and then I think it's really important to say, this is right across the street from me at 1420. They have rocks in their culvert, have had rocks in their culvert forever. And actually, you can't see it here, but on the other side, their culvert is completely smashed down and there's no access for water. You know, I've been part of Riverwoods since 2014. I came in renting this home. I'm a single mom. I work in Riverwoods. I came in renting this house in July. I bought it in April. I had a sewer line break and I had $90,000 worth of damage and a ton of water issues out front. And I've continued to improve the property. At no time did I ever want any issue with the village, or I had just pulled a permit because I put a fence up. So it's not like I was trying to do things without pulling a permit. I am at a point, the violation says that I need to remove every rock. I'm just letting you know, I have a child with special needs that now goes to a special school, and this has been a very tough year, and I'm exhausted all funds because I did not plan on having to pull all those rocks out. So I can do it by hand by myself, but that's at the extent of like what it'll be. I cannot.
Let me, Nicole. So Nicole fixed the problem. She made it even level. There is no more water problem. I got a violation too because I have the stones, and this was a huge surprise to me. I bought this land in 2014, end of 2013, beginning of 2014. So we did the construction, 2015. So all plans, everything was submitted to village. Contractor did excellent job. They coordinate with the engineer, with everyone. So everything was built as it right now. And Nicole is going to show pictures of how it was before building permit was issued, living permit, I mean. And then all of a sudden, 5 years later, I'm getting a violation that I did some violation. This is, if you can see on the top of this picture, it's the June 29 of 2016. This is before inspection. So everything was placed, and then inspection was made after. Then I got issued this permit. You can see the permit was issued December 2016. So everything was great, everything was permitted. All of a sudden, I'm getting violation notice that those stones are not to be placed there. I think this is really unfair, number one, and this is should not be going this way. You give a permit first, and then later on, 5 years later, you do punishment. Do you have to say anything else, Nicole?
I mean, no, other than obviously,
We did lots of improvements to the street. Before, it looked horrible. Water was everywhere. So many other houses, and I drove around, they have rocks in their cover, and everything is fine. So nobody is getting violation. All of a sudden, we're getting violation, and my rocks were permitted.
Well, thank you for coming in and making comment. If you'd like, we can have the village engineer reply to that. I believe the process would have you going before the administrative court, where you can meet with them and possibly work out a solution to this.
Well, we have an
I'll
attorney here. So
let the
let's-
village attorney correct me if I'm wrong on that.
If I get a permit for this in 2016, so how come it's a problem right now?
Well, I guess it would, one question would be what the plans that you submitted at the time showed. It's possible that a village official said that you complied with the plans that were provided, but wasn't aware that the rocks were in addition to what was submitted. So I can't speak to that. And this is not a good place to try and actually determine, what actually happened. That would be more appropriate, at the administrative hearing. But you're raising are questions about what happens when the village doesn't enforce the ordinance everywhere. That's something that the trustees do take into consideration. As you heard earlier from our Director of Community Services, enforcement here depends sometimes on discovery. We don't go around and look at every property every day. So when these things come up, we try and address them. You have pointed out other properties, and there is an ongoing discussion right now at the board level about what to do about culverts in general. So, there are policy issues here, but there's also the individual issue. I guess I would say, at the administrative proceeding, there's a hearing officer who's an impartial officer who can hear these same facts, and oftentimes will encourage the village and parties to negotiate a settlement to find some solution. So far, the solution that you suggested is to leave things exactly as they are. I'm not qualified to say whether that's appropriate given the regulations that govern stormwater drainage. So I know that's your preferred solution, but I don't know if that's a solution that the village can simply adopt. And for that, I would turn to our village engineer.
Well, we have an independent engineer who got this report that there's absolutely no impedance to water flow, and it's actually improved the water outflow. So if we're gonna remove the stones, there's gonna be, again, a great impedance to, I want to say blood flow, water flow. I'm
Well,
medical
that's-
field.
okay, so if nothing can be solved today, what is the violation says it has to be cleared up by June 21st. So when is this administrative board, and how do we make sure we can address that? So we, I'll speak for myself, I'm not in violation or have fines going or whatever else things you can do to my property. I want to be in good standing. So
Same for mine.
Can I call on a couple of the trustees? Trustee Clayton, I believe you had your hand up first, then Trustee Dickon, and finally Trustee Haber.
I just have a question at this point. My understanding of the situation was it little to do with whether a permit was obtained in the beginning, but the fact that the ditch was obstructed. And so is this really a question about permits, or is it a question that we have an ordinance that says that all ditches need to be maintained in a clear and unobstructed fashion?
Well, if you're asking me, I'd like to defer a little bit on exactly how that question should be answered. There is a violation when stormwater flow is impeded under the stormwater regulations. Our residents are saying that the stormwater flow is actually improved, but that would be contrary to what we've commonly understood when people put material in a ditch. I haven't seen the independent report that you're referring to, but again, I'm not qualified to say anyway. I'm only pointing out that if someone was claiming that what they had done was by permit and that they've come to rely on the permit, that is sometimes an affirmative defense in an enforcement proceeding. But that doesn't mean it's not actually a violation. It just means it could be an affirmative defense.
Well, the first violation on the letter that we received, and obviously Patrick can talk to this, was saying that for mine, a permit was not pulled to do work on the culvert. So mine has, I think, unless I'm reading it wrong, that the first and foremost issue was no permit.
Well, the problem with not having a permit isn't the permit per se. You're supposed to get a permit. The problem is, had you applied for a permit, there would have been a requirement for the kinds of studies and engineering calculations that would have allowed someone to determine whether it was appropriate to do the work or not.
And in my case, when we did a building permit, there was a permit. There was an engineering work done, all the sketches, all the diagrams.
Right, but I don't know if your engineering plans, do you know right now if your engineering plans showed that you were filling up the ditch with rock?
I have every single document from the construction.
No, but do you know whether that's what the plans show?
He reached out to his
Yeah.
engineer and did show, because we wanted to see, he had his rocks from day one. June of 2016, there's pictures. He got the occupancy permit in not till December, but in the actual plans, because he contacted the engineer, the rocks were there in the plan.
Oh,
We're
again,
going, may I take a minute here? We're kind of going through a proceeding here that maybe this isn't exactly the right place. Because again, the administrative court has an impartial hearing person that will listen to your case and listen to what the village has to say and hopefully bring those two things together. That's what those administrative proceedings are for. This is not that forum. But having said that, I do want to give Trustee Dickon and Trustee Haber a chance to speak. So Trustee Dickon, do you have a question or a comment there?
It has been addressed. Thank you.
Okay, Trustee Haber.
I'd like to hear from the village engineer, just to understand, what's going on from the village engineer's perspective.
Okay, thank you.
So it started, I got a phone call from a resident, not the immediate neighbors. It was another resident in the area that expressed concern. So I went out and took a look, and the Ms. Mayor was someplace in the process of having her contractor, I think, fill the ditch with stone. It's, to my mind, a pretty cut and dry conclusion that you can't improve the flow in the ditch by filling it with stones. You can certainly hide the water better, but over time, debris, leaf debris and such builds up, and all you've really ultimately done is just raised the level of the ditch and impeded water from upstream. And that's exactly what you saw in that photo that Ms. Meyer put up from Google Street View. That was the previous condition, that there were stones in the ditch downstream of her ditch, and of course all sorts of water visibly standing on her property. With regard to the permits that were issued for the construction on Mr. Glazer's property, no, none of those drawings indicated any, and it's not uncommon. There's oftentimes, it's a problem we struggle with all over the place. After the building permits are issued and the construction is more or less done, then comes the landscaping, which is often very different or certainly not reflected on the approved permit drawings. In both cases, I simply observed that filling the ditch with stones does not improve the drainage. It ultimately detracts from the drainage. And I don't deny that the ditches in the neighborhood are certainly, you know, they do tend to hold water. It is not uncommon. It's very similar to a lot of other locations in the village where, despite our best efforts to get the water to travel down the street, it really wants to travel, you know, a different direction. So, you know, it's very difficult to get the last bit to drain out. But that's the long and short from my perspective is I received a complaint. I took a look. Stones were being placed in the ditch, and that to me is a pretty clear obstruction.
Well, can I add? Number one, my landscaping was all done before a permit because that was a village's requirement to finish landscaping and then gonna issue the permit. For Miss Myers' property, they did not raise the ditch. They removed all the mud, all the dirt, what was causing all the problem with water, and then placed a special material, waterproof material, and then add the same amount of stone. So to keep the level going from north to from north to south to improve the flow. So those stones, they do not cause impedance. I mean, I'm not an engineer, but I'm a doctor, and I can tell you right away for flow of hemodynamics, which is a flow of blood. If there's well, I'm not going to go into details like that. We're going to talk about this later, but there was not a raise of the ditch. The certain amount of soil was removed and covered with a special material, and then the stone was added. And then my permit was issued after, before landscaping was done. So it was all on the plans.
Once again, I'm going to say that I think this is important information that the trustees hear as we talk about policies in terms of stormwater management in particular, and how we do that on both the public and private streets. But this really isn't the forum to settle or to come to some kind of agreement on what to do about your particular complaint.
Okay, so then what's next for
And
us?
what we do with violation at this point?
I don't know if we've prepared a formal, to call, I think, a charging order or citation. You've gotten a notice of violation, but there will be a follow-up communication letter to you with a date of administrative hearing. I think in the village, it's the
Third Thursday.
third Thursday of the month. We would do it in such a way that you have a minimum number of days of notice that you're required to have before the hearing. And so we would try and let you know when that is and give you a chance to prepare ahead of time.
So we could assume it's going to be July, not next week.
No, it wouldn't be next week.
No, not next week. Not next week.
Okay.
So again, I know this is troublesome for you and it's important information for us to hear. But we really don't have the ability to satisfy your complaint right here at this forum.
That's fine. Okay.
So we thank you very much for taking the time to come and speak with us this evening.
Thank you.
Thank you.
Okay. Are there any other visitors wishing to address the board? Okay, hearing none. Next item is approval of bills. Do I hear a motion for the approval of bills?
So moved.
Is there a second?
Second.
Is there any discussion? Questions, comments?
I do have a question.
Yeah, go ahead.
Please let me get to, I was looking at maps while they were talking. So I have a question. It's at the very end. It's under the TIF number 2. It's on page 8 of the bill. I'm sorry, page 8. It's under TIF 2, Capital Project Fund for Hooting Coyote, which is an engineering firm. I'm just curious what I understand the water tower maintenance part, but it says new building construction. Are we building a new building?
I think that was an old bill, to tell you the honest to God truth. Pat, do you recall?
Certainly that shouldn't be. There were two on the water tower, and then I asked him, I had one other structural review, if you'll bear with me just a second. I just don't recall off the top of my head.
Yeah, from time to time, we're discovering some old bills, so we,
Pat, was that the bill that he sent in that he didn't get paid for last year or last fall?
Was actually, so but it's not TIF 2, so it was two bills for the antennas on the water tower, and then one for going back to when we were reviewing the submittals for the shelter at the Flatwood Center.
Okay.
These are under the capital project.
They're under
funds.
capital projects. I'm sorry. It is under capital project, but okay, that's the only question I had. Thank you.
oh, okay, all right. Are there any other questions? Any comments? Do I hear a motion for approval, please?
So moved.
Do you have a second?
Second.
Okay, may I have a roll call, please?
Trustee Clayton,
Aye.
trustee Dickon,
Aye.
trustee Eastman,
Aye.
trustee Haber,
Aye.
trustee Hollander,
Aye.
trustee Jamerson.
Aye.
Thank you.
Okay, moving on to new business. Proposal to implement a two-factor authentication at the police department and Village Hall. Chief Dano, can you lead us through that, please?
Certainly. So I'm sure everybody's familiar with data breaches and ransomware attacks that have been occurring all over the country. And these attacks have occurred at municipalities as well. Some of them have not been well prepared and didn't have proper backups and had no way of restoring their data. We do a backup to the cloud in a safe environment. I'm confident of that. But if we did have any kind of ransomware attack, it would still be a lot of work to restore everything, although I'm confident we could do it after speaking to our IT people. So certainly I'd like to do whatever we could to even stop that from happening. So two-factor authentication would be our password that we're all using now to get into our village computers, usernames and passwords. But in addition to that, a second method would be required. It often comes in the form of a fingerprint reader, but in what our IT people are recommending is using two-factor through our cell phones. So when we log in to our computers, it would generate a security code that would go to the user's cell phone. So that would be something only that user would have access to. So it would make it much harder for somebody to conduct a brute force attack. It'll protect us against phishing, social engineering, and it would secure our logins from attackers who are exploiting weaker stolen credentials. So our IT people, Digital Currency Systems, our consultants, are proposing a project to set us up with two-factor authentication. And this would be a one-time project at a cost of $2,832.38 to set up our telephone, our users' cell phones, and all the computers in the village. Additionally, they're recommending that the village purchase Duo Access Plan two-factor solution. That would cost $6 per user, and I'm figuring for how many users we have and how many computers, that would come to $168 per month for 28 users. That's approximate. That could be give or take, because I have to find out who, if any, trustees for sure are accessing their computers. We used to have trustees who would do that. I don't know if that's needed anymore. So I'm recommending that we approve accepting the quote from Digital Currency Systems and then purchasing the two-factor authentication from Duo Access.
Just for minor clarification, Digital Currency is the company that currently maintains our hardware. right?
Yes.
Trustee Jamerson?
I just have a quick question. So this would be for all of the computers in the village hall and the police station, as well as the patrol vehicles, the laptops in the patrol vehicles?
Patrol vehicles are actually, because we're dispatched by Deerfield PD, we own the computers, but they manage the computers. And we're using the Deerfield two-factor fingerprint system to access our computers. Our computers don't touch, our laptops and the cars don't touch our server, they touch Deerfield's server.
Okay, I just wanted to make sure there wasn't a delay in response if they had to log in and wait for a text to come. And I see that as a bad plan, but it sounds like you got it covered. So, okay, that was my.
Trustee Hollander?
Is the reason that we're using a two-factor by cell phone rather than a fingerprint so that allows people off-site to be able to access the village's computers? Because it seems to me that if that wasn't the goal, that a fingerprint would be, which is physically in the village hall, would be better.
Some of us, including me, we do remote into the village server.
All right. Thank
Trustee
you.
Clayton, did you?
No, I was just going to say that I do access this remotely.
Well, that answers that question. Okay. I included you in the 28 users.
Yeah.
Okay, Trustee Haber?
I'm not muted. Okay, so I know that there's a couple of things that I've been reading about lately, even in my own office, things that have come up. One is that if you have network copiers, those network copiers are just as susceptible to being intruded as a computer. And if those network copiers are not subject to a two-factor authentication, there's just another access point for hackers to get in. So you might want to look into that issue as well, Bruce, because I assume that we do have networked copiers in the village. That's one thing. And the other thing I think that the village should start thinking about is to eliminate remote access to any of the village computers and taking the entire village business off the internet. And so that all email would be separate through a separate system. So that's generally how you're going to get hacked, is when you're interfacing between your emails into the network. And I think the thing that's being done now more and more from a security standpoint is to have an intranet for the village work, so that it's all in-house and cannot be accessed from the outside world, and having a separate system for emails, and the two never cross over. So I think that we should actually be doing a much broader investigation as to what is, our long-term goal from a security standpoint for the village. I think the two-factor authentication is good for now, but I think we really need to think about this on a much broader scale in the future.
Absolutely.
We do have a separate email system.
But the two can't cross over. That's the problem. If you have an email system that's accessing the same, office environment and being able to get into your, onto your servers and everything, that's the crossover that's causing all the problems.
Okay, I erred in that I forgot to send an invitation to Digital Currency, because I asked them if they could phone in, and then I just never sent the invitation, so it's probably too late now. But I'll ask them these questions.
I think this is worthy of just an ongoing discussion, and maybe another dive into our servers and who has access and who doesn't, and where things are stored. We do have a records project that we want to look at some point in the future, and Daphne and I have talked about that. So that's probably a good connector right there. How do we protect our records? How do we keep our records, and so forth? So point well taken, and maybe this is a good first step, but we shouldn't stop here. That's the message I'm hearing. Does that make sense?
Yeah.
Rick,
I think that we should move ahead with this. as a stopgap because it sounds like it's going to take a little bit more investigation to address Trustee Haber's concerns, which are very, very valid. So I think we should proceed with this and then continue the investigation as suggested.
Yeah.
I'll be happy to make a motion to that effect if that's, but.
Yep.
I'd be happy to second that motion.
Okay, that was a motion to approve this proposal and purchase for DCS for the quote and the ongoing two-factor solution. Okay, any other questions or comments? Okay, roll call, please.
Trustee Clayton,
Aye.
trustee Dickon,
Aye.
trustee Eastman,
Aye.
trustee Haber,
Aye.
trustee Hollander,
Aye.
trustee Jamerson.
Aye.
Thank you.
Okay, next is an ordinance granting a waiver from the zoning ordinance as a reasonable and necessary accommodation. Lori Brightcoff referenced that in the Plan Commission report, so I think I will turn that over to Lori or Bruce, whomever would like to speak directly to that.
Bruce, why don't you go ahead?
Some of the trustees are aware that we included a new provision in our zoning ordinance a few years ago to allow for waivers. The reason for this is that many federal laws and cases now have determined that if you have a village rule or regulation, including a zoning ordinance, that hurts somebody because of a disability, prevents somebody who has disabilities from accessing housing on the same basis as people without disabilities, or is otherwise discriminatory, it's against the law. And you know, there's a whole procedure with the zoning code for granting a variation. The traditional grounds for variation are demonstrating hardship, and we have very specific criteria for hardship in the village code. The criteria for granting a waiver under the the ADA and the federal laws, and what Lori referred to as necessary and reasonable accommodation, those criteria are different. They're found in Article A of Chapter 11 of Title 9 in the zoning code. When this particular application came to us, it's a house that's recently built, but it's a very deep lot on Riverwoods Road. The house was built so that it went basically from side yard to side yard towards the rear of the lot where it's located. And 3 years later, the residents find that they are suffering from decreased mobility. They talked about their issues at the Plan Commission hearing, difficulty going up and down stairs. And when we saw the application was for, well, it asked for any kind of number of reliefs. It asked for a variation, it asked for a special use, it asked for such other relief as the village would grant. It probably identified improper grounds for the kind of relief they were asking for initially, but you know, we didn't let that stop us. We looked at it and said, okay, what they're really asking for is an accommodation, because if we don't relax the side yard, in this instance, they won't be able to build the elevator. The Plan Commission wanted to make sure that that was in case the fact. And so the contractor for the owners also testified, explained how the house was built. It was all with solar panels on the roof and geothermal and pipes and ducts and everywhere. It's just very difficult, not even thinking about the actual floor plan, just thinking about where to penetrate the walls and how to put an elevator inside an existing house. And then layering on top of that, the floor plan and how the basement, first and second floor laid out and where it could make sense in the circulation of the house. They identified a spot on the east side of the house for an elevator shaft, essentially a square 10 feet by 10 feet. On that side of the house, it would encroach in the side yard by about 8 feet. So instead of leaving 30 feet to the side property line, it would only leave 22 feet. The nearest neighbor, the only neighbor to the east, is Orphans of the Storm, which provided a letter of support. Obviously, there's so much woodland between this house and Orphans that the Orphans didn't think it was a problem. So in the package, you'll see there is the Plan Commission report, which summarizes the arguments and the discussion and the testimony that was presented at the hearing, and also the Plan Commission's basic findings as to how this application, this particular instance, satisfied the criteria for necessary and reasonable accommodation. Behind the staff, the Plan Commission report are the materials that had been forwarded to the Plan Commission before the hearing. Application materials from the petitioner, additional set of floor plans, some pictures and descriptions of the elevator, and the memo that staff prepared describing the application and also providing some of the legal background for necessary and reasonable accommodation. This is the first instance that the village has actually made use of this section of our zoning ordinance. We adopted it trying to anticipate and be proactive about what could come to us. And we thought that this probably, and for reasons explained in the staff memo, that this was better as a case for necessary and reasonable accommodation than as a case for a variation. And so it was processed in that fashion, and you have the recommendation before you. Finally, at the end of these materials is the ordinance that would grant the waiver. Our code says that if you grant a waiver, basically adopt an ordinance that's in many ways like the ordinance that we grant for variation. It's the legal description of the property. It ties the relief granted to the actual plans that were presented to the Plan Commission. It's basically a waiver for the particular project that was presented, and we would record it against the property.
Trustee Haber.
So the only questions that I had were, number one, whether or not we actually did an independent investigation other than relying upon the contractor to determine whether or not the elevator could be installed in the home. I think we need to do that. And secondly, I just was wondering whether or not either of the applicants, the husband or the wife, were actually certified as handicapped in the state of Illinois. You know, have handicap license plates, etc.
Okay, they were not. They told us that they had not. One of them felt that they could have gotten a handicapped plate, but didn't feel it was necessary. The question came up, the Plan Commission, and what I said at the time, I think, was that the standard for disability under the ADA, of course, doesn't depend on an actual finding of certified handicap by the state of Illinois for parking privileges or something like that. The standard is different. It has to do with impaired mobility, difficulty breathing, difficulty with everyday activities. You certainly wouldn't get a certification from the state for that. So it would be convenient and more objective if we could say that we don't have to act unless someone can show us that kind of certification, but I don't feel that the legal precedents give us quite that degree of flexibility. And well, I could just, as to the structure of the house itself, it was just their contractor's testimony as to how it was constructed. We didn't have other testimony. We had floor plans, which I think are in the package. And from aerial photos, I can see that there are, I think, solar panels on the roof. I don't think they made that up, but that's what we knew at the time we had the hearing.
Trustee Jamerson, then Trustee Hollander.
Well, so my first question is the same as Trustee Haber's, and I understand the house was built 3 years ago. It's probably very energy efficient. If it's got, solar panels on the roof, that's great. But unless there's radiant heating in the floor, which there very well may be, putting a hole in the floor is probably not going to, whether they have geothermal heat or any of the other issues. So I guess my question is, I would like to see us have somebody independent look at the drawings I'm also a little curious about the fact that if the house is so energy efficient, why they're suggesting to put in a glass elevator on the outside of the house. If this is in fact the elevator they're talking about that they submitted, it actually can't be, because this elevator is only 44 inches in width. So they submitted something that is not what they're planning on installing, it looks to me. I was not able to go to the meeting, and I'm sorry for that, because I would have liked to ask these questions of their contractor and of them. I'm not necessarily against, you know, the variation or whatever we're calling it. But I do want to make sure that it's really necessary.
We can have this information gathered and provided to the board at the next, at a follow-up meeting.
Okay, thank you.
Absolutely.
Trustee Hollander.
Yeah, I was at the meeting. I want to bring out a few things for the board, so they have that information. And I'm more concerned about for the future. During the meeting, the individuals indicated that this was a preventative measure, not a measure to correct or to assist them at any time other than in the future. It is not for something to deal with now. So my first concern is if this is purely for preventative purposes, that really leaves us open for anybody who wants to prevent something a year or 5 or 10 years from now. Second of all, I understand that there are limitations on what we can call disability, and certainly as a board or a plan commission, we're not in any position to make a determination as to whether someone is disabled. But in this situation, we have absolutely no evidence that there's any disability other than the applicant's statement that they think they're disabled. I asked the question, as Trustee Haber did, about a license plate, and the answer was no. But we don't have a letter from a physician. We have no objective evidence other than they're saying this is what we have. And I'm not questioning that that's true. I'm just saying that it's hard to just accept that. And the third item that I wanted to bring up is that it seems to me that we make a variation approval that it's meant to correct something, something that's going on now. And by the Plan Commission's own information that they sent this isn't to correct anything now. This is to correct something that may or may not happen in the future. So I am very sympathetic to, as we age, being I think the oldest one on the board, and the conditions that might require some modifications. But I have concerns that if someone comes to us and says, I think I'm going to run into trouble in the future, I'm going to tell you what I have, and you have to believe me. And what I want to do isn't really going to help me now. It leaves us wide open to the next one. So I think I would like to have some objective evidence that there is a disability there, and that the variation will help ameliorate it now.
All right. The Plan Commission report does say that the testimony was that they have difficulty going up the stairs now. I know that the husband spoke a great deal about trying to prevent an accident, but his reasoning was that he can already see that his wife has a great deal of difficulty going up and down the stairs. So I know he said he was trying to prevent an accident, but the reasoning he gave, I believe, as was reflected in the report, was that because he observed difficulty now. But I think these are all great points because, we haven't gone through this before, and we certainly should find a way to document these questions.
Trustee Haber.
Am I muted? No.
No.
The other thing I recall reading in the report was that they have a floating staircase, and as a result of that, they couldn't use a different kind of a portable lift. I think one of the questions is, could the staircase be changed? I mean, before we, agree to waive something which would allow for a side yard exception, should they be contemplating doing something internally that would accommodate it, such as a replacement of the stairway? So that would be another thing that I think we should be thinking about. And then number two is, if we're going to do the waiver, if the board ultimately determines that the waiver is the right thing, I think that there should be at least some thought to, I'm not saying we would want to do this, but there should be some thought to reversing the structure, bringing it back. It's basically going to be a non-conforming use. If the property were to be sold, that use should be removed, or at least we should talk about that use being removed. I think for that, if you did that, people would think long and hard about actually doing it, because there's nothing that would stop a family from getting an exception and then 6 months later deciding, we're going to move, and now we have that structure forever on that property, non-conforming. So I think we should be thinking about, either amortizing the period of time or something, so that that's not something that we're going to have to live with forever if we're going to give a waiver.
Is there any other discussion? This was put on for a first reading and second reading, so
I think we have some homework to, get some more information and have a presentation before the board.
okay, so there are no motions, just a request for more information. Am I interpreting that correctly for the board? Okay.
I want to remind everybody that the Zoom recording is on the village website that has the residents' testimony as well.
Okay, I think we can move on. The final piece of new business is something I put on the agenda very quickly. Actually, that's not, is it? I'm looking at an old, sorry. We could talk about I put the Brushwood final estimate for the Brushwood signage project on the agenda. We received that on Friday, and it seems like because we want to move forward with these events, we need to act on this a little bit quickly. I apologize for not having a full memo. Along with Trustee Eastman, we have been collecting information from Brushwood about exactly, a little bit more background, and getting brought up to date by Trustee Clayton about Brushwood and the intentions with the signage and so forth. This is part of the original, I understand this to be part of the original Brushwood project, and certainly a part of what we had thought about. Now, if my understanding is not correct, again, I thought this was a good opportunity for the board to maybe clarify some of those things, but certainly I think we need to talk about moving forward with the signage part of the project. Trustee Jamerson.
So I just want to make sure I understand. This is for the Flatwood Heritage Center, correct?
Yes, yes, yes.
Okay. So it's really not a Brushwood Center project.
That's my fault for probably misnaming it.
Because it looks to me, as I just look at what's in the packet, the cost of the production of the signs, which is $5,518, and the cost of installation of the signs, which is $2,750. They're pretty much passing, although now I can't see the file because there's a problem loading that page. But when I looked at it earlier, they're pretty much passing those two costs along without any markup. So the only thing that Brushwood is getting out of this is the graphic design, which is $25 at $40 an hour, which equals $1,000. I need somebody to clarify that. And then I'd like to say a little bit about the Flatwood Heritage Center and where we stand with the budget now that the project is until Tuesday, we'll find out, but appears
Yes.
to be complete. So.
Okay, I'll toss out my understanding, and then certainly Trustee Eastman and Trustee Clayton feel free to correct me. Part of the, as I read the memo of understanding between the village and Brushwood, there was a memo of understanding, and then there was a listing of items and events and so forth. And on that was the Trail Tales. which was an installation and storytelling event. It says the Brushwood Center will work with the village to select, design, and create trail tale signage and programming specifically for Riverwoods residents. The access to that, of course, is free, but it in the last column in this addendum, it says not including design and installation of signage. Let me address the installation for a moment. Installation, I believe, was part of the original project budget, installing signs. And so I believe there's a credit available to us there. So that part of this invoice is, it's a wash. So we really aren't paying that. The signs themselves, the posts, and this is, I had a misunderstanding on this originally as well, but the sign posts and the signs themselves would be installed, but the content, you see the little animal on there, the little beaver thing, that content can be changed. So we are not installing the child's book forever and ever. We are installing the child's book content for a period of time, and that content can be changed. So again, the installation of signage in the Flatwood Heritage Campus was part of the original idea, design, and so forth. So what we're seeing here is just Brushwood getting quotes on the sign, the physical signage themselves, graphic design, and the storybooks for the first round of installation. So again, that's what I understand. And what we're really looking for from the board, because it's a larger amount, I brought it to the board, because it's part of this MOU, Memo of Understanding. It appears to me to be a legitimate expense on that part. What I am not clear on quite yet is if we have actually paid the other part, the second installation of what we agreed to in the beginning with the Brushwood people. So right now, what we're looking at in terms of approval is $6,518. And that would be for the graphic design and the production of the signs and the actual signs themselves.
That's not, well.
Is that correct? Is that, yeah.
I don't believe that's correct.
Okay, okay.
We've received, so I had to go back and look at the minutes from the meetings when the board approved the Flatwood Heritage Center. The board approved not to exceed $600,000 total for that project. As of today, the cost of that project was $569,045.15. That's what the contractor, that's what we paid the contractor.
Okay.
Included in that total is a credit for $3,012 for the installation of the signs. So we've already received credit for that. So we really need to, we're gonna have to pay somebody to put the signs in. So, and at this point in time, we're still $30,000 below the not to exceed number that was approved at the board meeting. And I didn't write the date down, but you can go back and find it. I didn't have a hard time finding it.
No.
So, and regardless of what the Brushwood agreement says, the only thing they're getting out of this is $1,000 for the graphic design. And if we want to go someplace else to do that, it doesn't make any difference to me who does the design. I don't care. But we're going to end up spending the $55.18 and the $27.50 if we want to put signs up, which the board approved to put signs up, regardless of whether Brushwood handles it or not. So
okay.
I don't know that, it's confusing to me that we keep talking about the agreement with Brushwood I realize this quote came from Brushwood, but the two things that they're not doing, they're passing through it, no increase. I mean, they're not putting any markup on it. And as a contractor, that's not the way, I mean, that's not the way I'm used to seeing things. If I
Okay.
do something, I put a markup on it. So,
Okay.
so anyways, that's, I just wanted to to bring the board, the current board, the board that was here when we voted on the Flatwood Heritage Center and the new members, that's where we stand with the budget, and that's where we stand with, and these signs were approved by the board. We didn't put them in because we didn't know what they were going to say, so they got left out of the construction bid. And there's, so anyways, that's the background from my standpoint.
Okay.
Just a
Yeah.
quick question then. Would the village be hiring Fossil Industries, or is the village signing a contract with Brushwood? I'm just trying to figure out, to me, it looks as if Brushwood has enabled this and put it together, but that the contract would be with Fossil Industries.
You know as much as I do
Well,
at this point.
the quote is from, I see that the transmittal came,
Mhm.
is Brushwood, who's supervising the labor and the work is, I guess, the question. Are we hiring Brushwood as a contractor, or are we simply going to hire the person they brought to us as sort of, and pay them the design portion?
Okay. All right. I think now we're talking about questions that need to be asked. I need to find out exactly what this means. Again, Brushwood, are you supervising this, or Brushwood, you're just giving it to me and I'm supposed to hire Fossil Industries to do this? Produced by Fossil Industries means to me that they are manufacturing the signposts and so forth.
Well, that's all. I mean, we have, we have to report as part of our grant procedures, because this is all part and parcel of the campus project. It's subject to all of the other sort of procurement and other sorts of, prevailing wage and stuff. So if it would be more convenient for I think for the village to contract to have this done, rather than try and have a third party do it, because then we could make sure that everything is done, correctly. They may have been trying to do a service for us by saying, we'll turnkey it, we brought it all together, but I don't know if they actually would let the contract. I just don't know.
Okay. All right. Then we're going to delay this. We need more information. Who does what? Who are we contracting with? How is this being put together? Am I interpreting this correctly? Trustee Hollander?
Maybe we can make it a little bit easier and make the assumption that as long as the village contracts with them, based on the information given, that we could at least get a first reading approval on it. So you don't have to start all over again.
Trustee Haber, did you have your hand up before? Okay, Trustee Jamerson.
I'm a little concerned that the people from Fast Signs and the people from the
Fossil Industries
are not going to be doing this as a prevailing wage project, because I doubt that either one of them, I know that Fast Signs works the village all the time, but they're not on capital projects. I'm wondering if the fact that Brushwood is handling it and turning over a finished product, as opposed to us contracting directly with Fast Signs and Fossil Industries, if that makes it more like buying a pre-made something, a bench, right? I mean, the benches were probably not built by union labor or even under prevailing wage, but the contractor that bought them and installed them was. So this is maybe a question for Bruce. I don't know what the answer is. But if we're going to put this through as a capital project, there's got to be prevailing wage to meet state law. And I'm guessing that neither one of these people are probably prevailing wage, and I guess that's my guess. So it may be something that we need to, and certainly to Trustee Hollander's point, we can do a first reading on this and, you know, move it along, but there's a lot of questions.
Yeah, I see what you're saying. Are we buying a finished product? Are we buying a signpost that they're going to deliver to us? And then we just have somebody install it? I don't know the answer to that. Trustee Dickon.
I had a question. Have we received comparable quotes to the fossil industries? I mean, $5,500 for 11 signs seems a little on the excessive side. And then I also had a question regarding the 11 signs costing $1,000. It's not unreasonable to spend 25 hours designing those at a very reasonable rate of $40 an hour. But or what kind of design are we looking at? Are these templates that have, or because if we're looking at a template design, then it really shouldn't take 25 hours. Again, this is a fairly small amount to dispute, but I'm just kind of questioning the overall process. And I'm sorry I've kind of come in late to this discussion. I understand some of this might have been discussed months ago.
If I can just address
go ahead,
your
Rick.
comment about the cost. Contracting is what I do. I mean, I'm an electrical contractor, but I deal with stuff like this all the time. And I'll tell you that these are black powder coated aluminum sign bases. $5,000 for 11 things like this is that's not unreasonable. So from that point, should we be getting extra quotes, that I can't tell you. I don't know where this came from. It's not, I mean, I didn't have anything to do with it.
I'm going to ask a question here. I mean, when we talked about having signage on the campus, how did we envision that happening at the very beginning? Did we envision doing it? And when we then partnered with Brushwood, they were going to just provide content? I mean,
when we first
was
did
there
the
a discussion
campus-
along that line? I don't know. Go ahead.
No, I think when we first did the campus, we weren't yet talking to Brushwood. And so when Trustee Jamerson was saying we got a credit from the contractor, the contract we have with the contractor would have allowed us to ask for some kind of signage. We didn't take advantage of that. That's why we got a credit back. So.
Well, and the credit was only for installation because and Trustee can jump in here anytime. We didn't know what the signs were supposed to say. That part was never figured out. And so the contractor, when they went out for bids to their subs, didn't put anything in their contract for the actual signs themselves because nobody gave them direction on what was supposed to be on the signs, and it actually fell through the cracks, which, I'll take.
Okay, that's fair.
I'll take the heat for that, but it fell through the cracks, and Trustee Clayton brought it up, that we said the job's done, but there's no signs, and he actually brought this up earlier this year, maybe January, February, asked this question. And I didn't have an answer. So, because we didn't have any content, we didn't know what they were supposed to say.
Okay, Trustee Clayton.
A couple of things. As I recall the situation, and I wasn't on the board at the time, but there were really two different, I think we're kind of confusing two different kinds of signs. The original concept for the woodland areas that are north of Village Hall was to include a cost program. For some reason, my mind's going blank here, where the demonstration programs for the various cost support projects that we do for like burning and invasives and all that kind of
garlic
stuff.
mustard,
All right.
yeah.
So there were going to be demonstration areas around, and there was going to be signage that talked about the woodlands and it's sort of educational signage. The second aspect of the project was ways to get kids out into the woods and to attract families to want to come and use the center. there were a couple dimensions of that. One was the natural recreation area for the kids, which did not get approved. But Trail Tales, which is basically a children's book that is laid out along the trail, that is a nature-oriented book and that has already illustrations and so on and so forth. That was always part of the conversation, at least as I recall, since about 2017. So this is a project where Brushwood took the initiative to, so we surveyed like 4 or 5 different children's books. We contacted the authors and got permission to use this as part of the Trail Tales project. And Brushwood was then going to pull it all together to install the Trail Tales. And Trail Tales was always sort of linked to Brushwood even before the more formal agreement was put into place with Brushwood. So the reason why Brushwood was involved in this was because they have expertise in the area with regard to Trail Tales, and they brought that to us at this particular point in time, along with the quote. So that's just a little bit of background. I hope that provides some additional clarification.
Are there any other questions or comments?
I have one.
Trustee Haber.
Not to create more controversy, but has anyone thought about whether these signs should be interactive? Because, you know, there are like 10-inch display signs that are very inexpensive and are interactive for outdoor use, and then can be changed very easily because they're all Wi-Fi enabled, etc. These are going to be, you know, stationary, stagnant signs that are going to be, every time you're going to want to change them, you're going to have someone else, you know, redesign these. So they may be cheaper in the short run, but more expensive in the long term. And also, to the extent that you're trying to identify with young kids who are going to be walking through this, kids are very savvy with these iPads and interactive displays and love nothing more than to be touching buttons and stuff on these displays. So just a thought. I don't want to reinvent the wheel here if this process is already, you know, 90% done, but it's a thought.
So where would you like to go with this? Do you want more information before we go further? That seems to be what I'm hearing, if I can paraphrase that. Okay, how many people would like more information before we move forward? Please raise your hand. Okay, that's one. Oh, two.
I think that, and I'm not going to raise my hand because I'm not sure I want more information, but I guess my question is, you know, so first of all, I guess this is a question directed to Bruce, because I don't know who else to direct it to. Are we done with the grant process?
Oh,
because
the OSLAD?
Yeah, because if the state, we have a grant not to exceed $300,200, and don't ask me where the $200 came from. It's supposed to be 50% of the construction, you know, of the cost of the project. So if we can get the state to pay for half of whatever it is we're going to do still, it might be worth trying to look at something like Trustee Haber was talking about, that's going to cost, even if it costs us $15,000 or $20,000, if the state pays for half of it and we don't have to physically change it again, which is a very good point, then maybe we should go down that avenue. I don't know anything about it, and I'm not going to volunteer to do the research because I've got too many things on my plate already. But that's just my 2 cents. And so I guess the question is, do we still have room and time to submit stuff for the grant to get reimbursed on? And does somebody want to do the research on that, or is this going to fall by the wayside? Then we run out of the grant and we don't get.
No, we'll ask Ben, because Ben is still involved. We haven't done our final audit report for the grant. We still are pulling together that information, so
Okay.
we can find out if there's still room to do that. And we can get back to you on that. And I think as a minimum, it's hard for me to recommend how to go forward without knowing who the contract is with. That's sort of my basic concern, along with prevailing wage and those sort of things. So we'll just try and get some clarification on that before we come back to the board. I don't think it'll put back the opening of the campus, by that much if we get this information.
Yeah, I think I'm trying to remember when we have, they've scheduled the Trail Tales events. I think that's why, I think they're coming up on that, which is why, again, I put it on the trustee Holiday.
I just want to point out that we're a small village, and if we have a Wi-Fi enabled graphic for the 10 or 11 signs, which I think is a great idea, it means that someone in the village is going to have to be keeping that current.
Oh,
figuring
trustee
out-
Haber will do that.
we don't do well with this sort of stuff. And and I just don't want to add more expectations than we can really meet. So I just bring that up. I think it's a wonderful idea.
Oh.
And yes, you may want to look into it, but I don't know who's going to take responsibility to deal with it all the time.
Trustee Haber, trustee Dickon, please.
Yeah, I just wanted to piggyback on that. I think the idea is great, but we're also opening up a new can of worms of maintenance, because kids are going to be playing with things are going to get damaged. And so we would need to allocate a future budget for making these signs sustainable. There's going to be tons of repairs, things falling on them throughout winter, rocks, branches, anything electronic. I'm a mom of 3, tends to get damaged. That's all.
So there. Yes.
How about this? If we find out that there's a way to contract on this that makes sense, we could probably place the order and come back for the board for approval. I don't think they'll be made before we meet again. So if we find that there's a way to do this, it's very close to the mirror spinning authority as it is, just to have the signs made. Are we happy with the design of the signs?
Trustee Hollander.
I'd like to make a motion that we approve this, assuming that it meets all legal obligations.
Would you like to put a budget on top of that?
The budget is as it was presented to us. I don't know what the dollar amount was.
$9,268.
Subject to village attorney review.
Correct. Yes.
Well,
Budget of
I'll second-
$10,000. A budget of $10,000 maximum, subject to
Okay.
the attorney's approval.
Okay,
I'll second that.
all right. Is there any more discussion? Roll call.
Trustee Clayton,
Aye.
trustee Dickon,
Aye.
trustee Eastman,
Aye.
trustee Haber,
No.
trustee Hollander,
Aye.
trustee Jamerson.
Aye.
Okay, thank you for that. There's one more thing on the agenda. Bruce, would you like to go over that
Yeah,
emergency?
we can't take action on it because we didn't think about it until too late. It wasn't on the agenda long enough, but we can discuss it, and it's not a lot of discussion. It's just basically, we have an old ordinance on soliciting while being in a street. There was a court decision that came out recently that criticized the community for having this kind of ordinance, because the ordinance referred to standing in the street. It's an anti-panhandling ordinance, but it was standing in the street to solicit for A or B or C or D. And so when the ordinance went to the pain of saying, if you're there soliciting for A, B, or C or D, you're actually speaking. It's a type of speech. You're advocating for A, B, C, or D, and therefore the ordinance was regulating speech and was not content neutral, and it was therefore unconstitutional. So Chief Dano and I kind of quickly scoured our solicitation ordinance and decided it's a little too close to the edge for comfort, and are quickly repealing the provision we think is potentially a little at the edge and suggesting a more neutral, much more neutral replacement.
Does this apply to public or private streets?
It applies to any street, but I think it would be mostly enforceable on public streets. I don't think we could enforce it on private streets, the village.
Does the ordinance address public or private streets, the proposed ordinance?
It says, I think it says public highways. I think it refers to public streets
Okay.
by memory. I don't have it in front of me.
So I can come to your street, Henry, and solicit, is that?
No, I mean, as long as we're discussing it, I would have an objection to having the ability to anyone to come onto a private property, a private street, and have the freedom to use microphones or loudspeaker systems or march or anything like that.
You
So
know,
if we're going to do an ordinance, I'd like to at least have that addressed.
I will take a look at it.
Are there any other questions? Any further discussion? Bruce, I think you'll be back with something then.
If it would be okay to have a first reading, I think it puts us in good standing to know that we're moving to act on this.
Do I have a motion for a first reading?
Oh, can't take action. I take back what I just said. 'Cause
Yeah.
we
I
didn't
take
have
back
any
what I
time.
just said.
Sorry. Apologies.
Okay, we'll have that for discussion at another time. One thing left on the, well, I don't see any need to go into executive session unless someone else has an issue. Okay, establishing the time and date for the next meeting. There was some discussion about didn't seem to be enough on our plate to have another meeting on July 6th, which is right after the 4th of July weekend. And other than bills and standing committee reports. So I was going to poll the trustees and see if they wanted to cancel the next meeting or if they felt we needed to go forward with the meeting. Trustee Hollander.
Whether or not it may make a difference, but I don't think I'm going to be able to be at that meeting. So
Trustee Clayton.
I'm also not going to be able to be at that meeting.
Okay, will we have a quorum?
barely.
Barely.
I say we should have the meeting because those two people aren't going to be here.
Great idea, Mike.
What subject do you want to put on the agenda, Mike?
I got about
What would you like on it? Yeah,
I'll be emailing you later, Chris.
it's a secret, Henry. You're just gonna have to wait. Okay, we'll go forward with the July 6th meeting then. And I'm sure we'll see something from Attorney Haber. Attorney Haber. Well, we'll see something from him too.
I'm
We'll see
actually
something.
fine with it being, if there's not an agenda, then if there's not a sufficient agenda, then I would suggest that we should probably just cancel it. Unless anybody else has some grave concern about being here on the 6th.
I would agree that, I mean, I don't think, if there's not enough on the agenda, there's no reason to have a meeting, but.
Well, I ask you that. The only thing I see coming up in July is frankly the SSA. There's some SSA things that have been put over till the second meeting in July.
If we're going to, if the SSA, this is the funding for the SSAs?
This is the hearing on whether to form them.
Yeah, we haven't had a follow-up, but I'm really interested in knowing whether or not the village can take part of that type of a loan based on a higher interest rate. And that was never, I'm not pushing for an answer now, but I know that that's been sitting out there. And I certainly would like to have that information before that comes up, or at least the same time as it comes up on the agenda.
Sure. Okay. Trustee Clayton.
I don't know if this is exactly relevant, but by mid-July, we are planning to have a new 5-year financial forecast for the village and a more solid forecast for this year. And I had asked the mayor whether we wanted to have another workshop like we've had, I think, last February, to kind of go through that and discuss our financial situation and where we're headed. If we are going to have a workshop, then that would actually be an additional get together. And so if we wanted to cancel the 6th meeting, it would still be 2 get-togethers in July. And again, for what it's worth.
Yeah, I think that I understand in the past, we've had something called a committee of the whole rather than an actual board meeting, which means we could get together and, receive that information and discuss it, but we could not act on it. That might be a possibility for us to do, and we could push the meeting back till the following Tuesday when we would have better attendance. But then we would have 2 meetings in a row, one on Tuesday, the 13th, and another on the following. Yes,
I couldn't be there for the 13th either. So it wouldn't be good to have a finance presentation, I don't think, at that point.
probably not. Okay, well, we
And we
can.
won't be ready.
All right, well, we'll push things back. The other reason for holding the meeting on the 6th, the only other reason I can think of is for the trustees to receive the report that the completion of the Flatwoods Heritage Center has been agreed, and we will start planning some kind of a mid-July opening. But I'm not entirely sure if that rises to a board level concern.
Bruce, can Chris make the call, on her own, and just determine as we get closer to July 6th, whether or not there's a need? And if not, can she just cancel it, or do we have to actually have a motion?
I don't think she can send out a notice saying that there could just be a lack of a quorum. So, I mean, if we just all decide that there's not going to be a meeting, I don't think there has to be a motion. I think the mayor can decide that there's not enough on the agenda, suggest that there be no meeting that week.
So maybe we can just see how things develop between now and the 6th. And if you feel
Okay.
there's a need, then we can just do it. And if not, then you'll just send out a notice that it's not happening.
Okay. All right, we know for certain we don't have 2 trustees, so as I say, the only other issue that I can think of would be discussion about a campus opening, which is more of a party decision than a board decision. Okay, let's go with that. We'll just keep you updated, and right now we're going to schedule the meeting, and but it has the potential to be canceled. Is that agreeable?
Yep.
Okay, then. Oh, I'm sorry, trustee Clayton.
Just one more thing for the good of the order. We have a music and nature program for children aged 1 through 5 this Saturday at 10 a.m. Run by Brushwood, if anyone is interested in attending. So far, Katie tells me that we are getting some solid attendance for the event.
Where is that going to be at?
The Village Hall.
Thanks.
Okay. If there's nothing else, then a motion to adjourn.
So moved.
Second. Roll call.
Trustee Clayton,
Aye.
trustee Dickon,
Aye.
trustee Eastman,
Aye.
trustee Haber,
Aye.
trustee Hollander,
Aye.
trustee Jamerson.
Aye.
Thank you.
Well, thank you, and good night, everyone.
Good night.
All right. Thanks.